All right, we are live with quite a lineup here. We have the two Steves. Andrea Burkhart is back. How are you doing?
Doing great.
Dave from MLS Law Show and Sean, potentially criminal. How are you guys doing?
Good.
Doing good. Coming off SHA Business, diving into another one.
I think Chandler will be joining us. Different people have different timelines. So if we can, let's start off with SHA Business, who I think half of you guys were covering that the whole time. Who wants to jump in and talk about the least surprising verdict in history?
Steve does.
Steve.
Steve, which Steve?
Gosney wants to talk about it.
Well, I'm going to have a grading the parties live stream at 8:00 on Rumble and YouTube's. Was it Nick Ricada and I were having major disagreements as to the defense. I think the big controversy in the case is not the guilt, because it was kind of pre-set in cake and predetermined. It's how do we rate and grade the defense attorney, because we really saw a great judge at work, and it's a little hard to kind of, when you peel that back, because a great judge will make the people in the courtroom operate better, and specifically the prosecutor's office. So, it's like we have seen so many cases where prosecutors cheat and, lie, cheat, and steal to get a conviction. Not that it was required here. I mean, this was sort of a direct case. You don't need to do that. But, and you shouldn't do it if it's a weak case, right? So you should never do that. But the fact that this judge was such a by-the-book kind of judge, and he had command of the courtroom, his rulings were clean, he was fair, he was right down the line, and I expect that he doesn't tolerate bad behavior out of his prosecutors. So how much of that is attributed to the prosecutors and how much is it to the judge, I don't know. But I think that if anything I can say, I would say I am a big fan of this judge, best judge I've seen in any law to broadcast, trial that I've seen.
That's
Steve,
rare.
can I make a comment on that you can explain to people better than I can, but something I heard and caught, and that is when the defense was talking about putting on a case, and I think I ended up missing it, that they didn't. There was a witness they couldn't get to come, and I heard the defense counsel say that the prosecution and the defense had some facts that they might stipulate into the record, which to me was an indication of professionalism on both their parts, that they would talk out away from the judge and say, hey, if this guy can't come, we would agree, that this could be presented as a fact. Now, the DA may want to do that to make sure the case doesn't get mistrial or delayed or something like that. But I guess to me, that was a symptom of professionalism that I saw an undercurrent of between defense counsel and the DA, trying to keep things that didn't need to be fights from being fights. What do you think about that?
Yeah, that's a very good example. There were numerous examples of that you saw kind of throughout the trial. And I think that's the judge is encouraging that and creating that kind of atmosphere of playing it fair, playing it down the line, so that if either side gets out of line, he's going to knock it down. So that encourages a game of fair play. When you have the judge that's unbalanced one way or the other, you get an unbalanced courtroom where, yes. And I think that was a very good call by the state, because, I really have, states got to be very careful when they object to things like jury instructions or evidentiary rulings or defense witnesses that they want to come in. It's like, they know they got this in the bag. Why screw it up by making objections that are, if you win, you might lose. So you're better off just saying whatever the defense wants on the jury instructions, let them have it, right? Whatever they want to get that in, I'll open the door and not object. And you saw a lot of that happening, which was good for the prosecution, professional for the defense attorney. And a lot of the credit for a clean trial goes to the judge.
All right. So what was the actual outcome? Does somebody want to break that down?
Southern law, you covered most of it, right?
Yeah, well, she was found guilty in a pretty short order, which was not unexpected because they were able to put her confession tape in. I'm sure they had a motion in limine on that. I think for sure that they did before that in the defense law. So whether that ends up on appeal or not, I don't know. But it came in during the trial. And when you have her describing in detail what she did, plus all the other circumstantial evidence, guilty verdict quickly was the right answer. But then Wisconsin has that procedure where if you plead not guilty, but then not guilty by reason of insanity, they break the trial into two. They bifurcate it and they have a phase two. And then they determine whether you suffered from a mental disease or defect that impeded your ability to know right, wrong of your conduct or created a compulsion you couldn't control. And that to me was going to be the more interesting part of the trial, because what she did is you know, in any common terms would be bonkers or crazy. That's not the legal standard, and insanity is not even a medical term that they're going to use, right? So you try to marry the law to the medical side and have the jury understand what this is really about when the actions are crazy. And some people say, well, she's acting crazy. I mean, to me, she has mental problems, and it really was down to whether she could know right from wrong or not. I think that was the more complicated piece, but it was not apparently complicated to the jury, who returned quickly a verdict on that, not in her favor. She only needed 10 out of 12 jurors because she has the burden in phase 2 to support her insanity defense, but she got 0 out of 12 in pretty quick order. So she's going to go into prison.
And the prosecutor on rebuttal, I thought, was very good about nailing down the fact that voluntary intox and creation of mental problems by use of illegal substances, voluntary intoxication does not fit within the compulsion you could not control box. And that was the kind of the key issue that the jury really, if there was an issue here, that was the one that they would have had. And I think the fact that she was a meth head and she's a voluntary meth head and voluntary drug user on all kinds of substances, the state's rebuttal on that was very clean, very direct. And so thumbs up to the prosecution for keeping it fair, keeping it on the law and on the facts.
I'd love to get your thoughts on this. I've spoken with Dr. Shaham Das out of England. He's a psychiatrist who literally works with the criminally insane in their main institution. I forgot the name of it, but it's a famous one that, you know, all the books and things are written about. He was talking about how it's not necessarily good for a prisoner or criminal to be in a hospital if they are not truly criminally insane, that their life and conditions are better in a real prison because they're with more normal, like-minded people, which sounds really awkward, but it is true. And it made me think of like One Flew Over the Cuckoo's Nest, how he was trying to fake it, and ultimately we saw how that went down. Do you guys have any thoughts about that? Because I'd never heard of it discussed in that kind of a manner.
You spend all the... Oh, go ahead, Andrea.
I was going to say, I'll go ahead and jump in on that one a little bit, just because it's something I've seen quite a bit. In fact, I've got a client right now who we just won her appeal. She'd been in prison for about the last 5 years. She's obviously not in the hospital, but she got remanded back to the county jail. And people don't, I think, always realize the difference between, the ways that people can be imprisoned and the just types of scenarios that are present in that circumstances. Prisons today are fairly, normal. People have jobs. There's programs you do. You can go to school. You can go to the library. You can, you have your yard time, spend time outside, spend time watching TV and stuff like that. It is a fairly normal structure for the most part. If you're in, general population, you're not in closed custody because, you wouldn't be safe in general or something like that. Jails and hospitals are very, very different environments. Like you pointed out, hospitals are mostly going to be full of people who have different types of mental disorders. And so, if you're not schizophrenic, if you're on a ward with, a lot of schizophrenics, you're not going to have probably a lot of connections with these people. It's not going to be a situation like in the prison where you can go to your job, you can go get your GED. These other opportunities that are out there, it's really exceedingly boring. And, you're in a treatment regimen that you're probably resistant to, depending on what your issue is. See, a lot of times when people are pursuing an insanity defense, but they aren't really insane under the legal definition, their real issue is personality disordered. They've got some conduct and kind of social interaction types of issues. And those aren't going to be things that serve you well in a hospital environment where you really need to kind of go along to get along. You're doing like group therapy and stuff like that. You're likely to be disruptive. And then if you're disruptive, bad things happen. You get, tied down to a gurney and things injected to you that you don't necessarily like. So yeah, it's a very, very different scene being in a hospital. In this particular case, even if they were equivalent, it might be, 12 of one, dozen of the other, because you're going to be locked up for the rest of your life anyway. But a lot of times in cases where insanity is on the table, you're not looking at a life sentence. You're looking at maybe say you're looking at 10 years in prison, or you can plead not guilty by reason of insanity. In my state, for example, you would almost never pursue the insanity defense because you can be locked up in the hospital for the rest of your life. It's basically discretionary, until you're at a point where you can be safe out in the community again. And the types of, political boards and appointees and stuff like that make those decisions are inclined to be conservative about what is going to be a risk to the public. Because they don't want to release you and then you do something and they're going to be accountable for that. So in non-life sentence situations can be significant downsides to pursuing insanity because you can end up being incarcerated for a lot longer than you would be if you just got imprisoned and went to prison.
Well, I was going to say the same. I had an ancillary case. I didn't represent the defendant himself. I represented the father in sort of a guardianship and stuff, but he was charged with arson for attempting to burn down his house. And he pled under advice of counsel, someone else, not guilty by reason of insanity. Now, this would have been like a 5-year sort of sentence. I think he's still in there. That's the problem. And so you don't do it unless you're really facing something severe.
Or if you're really insane. And that's why I found that just so fascinating, because one would think that they're getting over, quote unquote, and maybe that's the general perception. Kurt, hey.
Hello.
I just had never thought of that before, that the idea that if you are a sane criminal, being in an institution would be pure living hell, potentially. And the joke is on you if you pull off your stunt.
I mean, I guess the question really is, depending on the penitentiary, like what kind of hell is prison? Is it like Oz type of thing where it's like, you have to pick which devil you're living with, where you're either going to be, continually sexually assaulted or, in risk of being shanked, depending on which gang takes control of the cell, or is it, relatively more like Shawshank, where it's like, it sucks, but it's like, you can form social relationships, and that probably might vary drastically from one prison to another. I would imagine.
Could be the crime, now that you bring that up. Like if you commit a crime that's especially hated by other prisoners, I could see where you're like, you know what, never mind, I'll take the drugs. I don't want to go in there. I may not survive it. I might be like Dahmer or something.
Well, so, I think Andrew's point is a good one, though, because while usually you can petition to get out on conditional release or something like that, if you did something horrible, that even if the burden is supposed to be on the state or whatever, they're not going to want to just let you out. And, I have visited secure mental institutions with somebody who killed more than one person, not guilty by reason of insanity. And I didn't spend any more time in it than I could. And it was nowhere you wanted to be. And this person was is highly intelligent. And but however, was dealing with insanity conditions. Nevertheless, that's a frustrating environment for somebody like that. And if you don't need that treatment, you don't want to be there. Probably if you do need the treatment, you damn sure don't want to be there if you don't need it. It's nowhere you want to be. It's not easy street.
If I read the Wisconsin law correctly, though, I believe in Wisconsin specifically, even if you're committed in this criminal proceeding, you have the right to refuse medication.
Yes, unless I thought that the judge has to order it. Here's what I looked up.
It has to be like specifically ordered.
Yes,
so
exactly.
It's a little unclear.
Yeah, so the judge commits you to the Department of Health Services, and people take that to mean when you go off to the institution, but the judge has to make a finding whether it's institutional or conditional release. Now, with SHA Business, if she had been insane, that would have been institutional for up to the maximum sentence that she could have received. Then every 6 months or so, she could petition for conditional release, but let's be real, that's not going to happen anytime soon. But, after a long, long time, maybe you could get that. But that's your hope, I suppose, if you are really insane, is that they do help you become better and eventually you can have some kind of life outside the institution. But that is a very uphill battle.
And even when you get released, you're then subject to court review generally every 6 months, maybe a year. And if you start backsliding, guess what? They're putting you back on the bus and you're going back in. So you're never out completely.
Could you
But for
also
the protection of society, it's not a bad thing if you truly do have some sort of mental health issue, right? So if we're looking at even not only from the defendant's standpoint, from a societal standpoint, it's not necessarily a bad thing. So people who are, oh, you know, this person should not get off by reason of insanity. People that are saying that don't understand the hoops that this person is going to have to jump through for the rest of their life. By getting that not guilty by reason of insanity.
And a last point, aren't there some conditions too where somebody will be sent to a hospital and be treated enough to stabilize and then sent to prison?
Well, that's usually going to happen pre-trial. That's going to be like a competency type of situation, not so much an insanity defense. It's when you know, client gets appointed to me and I go and visit them in the jail and they are like floridly psychotic. They are hallucinating. They're talking to people that are not there. We can't communicate on the same level in a way that's going to allow them to have a meaningful defense. So in that type of situation, yeah, very common. They'll be sent off to the hospital. They'll go through competency restoration, which basically means medication. They'll be medicated with antipsychotics and see if it works. Basically, a lot of times it is. Competency is restored, and then they're brought back to basically stand trial.
But following on with what Andrea says, if SHA Business had been found not guilty by reason of insanity, she would not have faced a criminal sentence later if she were ever released.
Yeah.
I was gonna say there's also like companion cases that can kind of go along. I've represented a couple of people where in Michigan we have a mental health commitment because something is going on. Either, you know, they have a mental health issue or they're not taking their medication or whatever. And then that could be, in addition to that, they could also have a criminal case, you know, completely separate from each other. And so sometimes they'll work hand in hand with each other. So they'll get a criminal conviction maybe, but then also do the mental health commitment treatment, which is much more intense than they would ever get with probation or anything.
I was just very pleased the jury came to what seemed to be the obvious decision. Whatever her mental problems are, she's not anywhere close to what the insanity defense is designed to capture. So it was an inherently absurd argument, sort of on its face. Does she have problems? Yes. But we all have problems, okay? I was like, when some of the things that they were talking about, like some of these things describe me or my friends. It's like, you know, so
hopefully
it doesn't mean that you're crazy to be in society.
There's a shorthand that gets used sometimes in mental health environments, which is when you're talking about people that are hospitalized, you can categorize them as mad, bad, or sad. Okay, mad are your people who are, you know, again, psychotic, delusional, not on the same plane of reality as you. Sads, people who are depressed, you know, deeply depressed, potentially suicidal. And then your bads, your people that just have personality disorder, behavioral impulse control problems, and things like that. Bad tends to not fit in the insanity. Insanity tends to be pretty limited to the mads, sometimes to the sads if you're deeply depressed to a point of losing contact with reality and stuff. But the bads are almost never insane. They're
not
just
treatable
bad.
though. Isn't that the problem? Like a personality disorder, from what I understand, is permanent. It's not like you can get medications or get a balance from psychopathy. There are
therapies
for different,
for different, depending on, if you have a cluster B personality disorder, I believe like DBT helps a lot of those. There are certain kinds of therapies, and also depending on when that diagnosis is given, because you can be diagnosed at say 20, but the brain isn't fully formed until say 20, 25, 26. And so if you work, really closely with a psychiatrist who really knows how to treat that kind of personality disorder, there are, methodologies where you can work through certain things. But for some people that, personality disorders are very pervasive and very locked in and resistant to treatment, it depends on, how self-aware the person can be, if they actually want to change, if they actually want to apply those therapies. Some people do, some people don't. I think with SHA Business, she had a combination of, some traumatic life events. She had, like, her mother died when she was very, in a very vulnerable place when she was, I think, in her early 20s. She had, the meth addiction and the drug use, which I think exacerbated some of her conditions. And then additionally, she had like a potential bipolar disorder, which I don't think was ever formally diagnosed. But if she did indeed have bipolar disorder, the meth use and the trauma from the loss of her mother, etc., definitely would have exacerbated those things. I don't know exactly, how that all fits into the crime that she committed because she was under the influence, but, like we said, voluntarily intoxicated. So anyway, ultimately, that's my contribution for that particular question.
All right. Speaking of unstable, I believe, Dave, you're covering the Crumley case.
Yeah. So I've the whole reason I'm on YouTube is the Jennifer and James Crumley charge, and so that was my first thing I started streaming. Yesterday and today, Ethan Crumley, the Oxford school shooter from November of 2021, is actually having a Miller hearing. And this is the county I reside, so I've been covering that, and I'm very interested in this case. But I kind of see this as a preview of potentially the case that's going to be brought against the parents. So it's very interesting. But essentially, the state in Michigan, we have a presumption that we will not sentence a juvenile to life without possibility of parole. The state has the ability to rebut that presumption by presenting clear and convincing evidence that the child's essentially not rehabilitative and is going to be a danger to society. There's a bunch of Miller factors and things like that that they need to take into consideration. So they've been doing that for the last day and a half now. A lot of it is kind of irrelevant, a lot of the testimony, but it's a good preview for what we might expect for a trial against the parents, actually. So they go a lot into these text messages and journals and what the parents knew and didn't know and things like that. But so that's what I'm covering now. And I thought it was just going to be a 1-day hearing. And so when I found out it was 2 days, I jumped on last night real quick and streamed. Steve was there well, you were there. I can't remember. Joe popped in for a minute. Chandler popped in. Sean popped in. So it was great. But we're continuing that today. We've been streaming this morning. They're on lunch break now, and I'm going to go back to that again. But yeah, it's kind of a tragic event. The Ethan Crumley saga wasn't really terribly interesting to me because it's kind of obvious, like SHA Business, right? We know he did it. He pled guilty to it. But I'm really looking at this as more of a preview as to how the parents are going to be treated going forward. And I'm not a fan of the idea of charging the parents with manslaughter. Maybe something else, but not manslaughter in this case.
In the future, if you want to cover that with me, I'd love to stream that with you because I've been following that case as well. I think it's really interesting on the facts and law.
Yeah, I'm going to redo. I did a stream early on of the preliminary examination. I'm going to redo that now, kind of in hindsight, in preparation for their trial. The parents' trial right now, the parents' case is with the Supreme Court of Michigan. It's probably going to get kicked back down in August without a decision. And so I anticipate trial going forward in November or December. Talking with the court staff, that's possible. It's also possible that it'll get kicked off to January, just with the holiday schedule.
It also has massive social implications. I mean, as the appellate court noted, no state has ever charged parents of a shooter before. I mean, that's and it's astonishing in this age where accountability seems to be something that is so duly lacking in our society, that we're going to be broadening accountability for a school shooting in ways that no one's ever done before. I mean, it's so completely the opposite of the way society tends to look at, like, let's forgive everyone, forget, everyone has their problems, and to excess and in a damaging way to our society. And now on this issue of accountability, we're going to say to the parents, yeah, you weren't involved in the shooting, you didn't really, but your alleged recklessness enabled this to happen, so we're going to hold you accountable. It's such a bizarro world.
Yeah, what about the administrators?
But
what
I don't know
about the damn
When does
school?
When does the school ever get accountable?
Right.
Well, that's the thing. So if the parents are accountable, then so too must the school be, right? Maybe even a little more so. But they're not bringing charges against any school officials.
You would think so, particularly because in the case of schools, the idea of in loco parentis is sort of well established. So they're in the stead of the parents, so that should come with a whole bunch of fun and
This
consequences.
is bizarre. Wait, I thought the basis for the manslaughter was some argument that, like, they were reckless in allowing him access to firearms or something like that. Is that not it?
Not really. No,
not really. I mean, that's part of it, but the other part of it is that they knew he had some mental health things. They talked about text messages from months prior or years prior where he was like, I'm seeing ghosts and all kinds of stuff. And he had a dog die, his grandfather died, and his best friend moved away. They weren't getting him help and things like that. The day of the shooting, The school called the parents in and said, he's doing all these drawings. We're concerned not about homicidal, but suicidal issues. Can you get him counseling? And they said, yeah, we've been looking at that. And in fact, the mother was texting a friend of hers, they have horses, about doing equine therapy and getting him interested in other hobbies and things like that to kind of brighten his spirits. They did recognize a problem. And then the school said, we would like you to take him and get him into counseling today. The parents responded with, well, we have work. Does he have to leave school? And the school said, no, he's fine to stay. Meanwhile, the teacher brought the backpack down from the classroom, which had his journal in it with all of his thoughts and the gun, and handed it to him. And then like an hour and a half later, after the parents left, he shoots up the school.
Yeah.
Wow.
Where the appellate court particularly lost me in their analysis was the suggestion that a reasonable jury could find that the parents could have predicted the school shooting was going to occur that day, not at some indefinite point in the future. Not that he was a homicidal risk at some point in the future, but he was a risk of a shooting that particular day. I'm like, wow, that is a lot of foresight, man.
Could have predicted is now the standard. I mean, could have predicted. I mean, because
let's
I was
have
curious.
some account about how about the mental health professionals that are treating these people. So you get a mental health professional that doesn't predict the shooter. You went to school, you studied, you've got a PhD in this, and you can't predict that this guy's going to go kill. Let's hold the doctor responsible.
James Holmes' therapist should have also been charged because the
well,
therapist was treating him and shouldn't have.
Kurt, to your point. Oh, sorry, Sean. Go ahead.
No. The idea, though, the school administrators, they think of themselves as the experts. They know kids. They're like, we can fix them. We know all about them. Trust us. I mean, how many times do you hear educators saying that? You know, we should be the ones telling kids what to do. Don't, you know, who are the parents?
And they have legal custody of that child at that moment in time. So are they personally responsible?
Well, that too. And also, I still don't understand how the person carried his backpack with 3 pistol magazines inside of it, which when those are fully loaded, they're rattling, banging around, and a gun.
Heavy.
And and somebody was like, "Oh, this seems fine."
Why didn't they?
The other thing is, you know, people said that well, the backpack is heavy. Well, it only had like a journal and some charging cords and a laptop. I mean, I don't know, but to Kurt's point too, the opinion from the Court of Appeals flies in the face of a very opinion that the trial court made when the prosecution attempted to introduce an expert on the pathway to violence, saying that they could predict this based off of behavior. The expert's own testimony during a Daubert hearing said, we can't predict this.
Yeah,
so the judge excluded that. And that was before the Court of Appeals decision. And so this is nonsense.
So, Joe, on your point, before you go off, I did want to say that this isn't unprecedented in this time because Deja Taylor in Virginia, her son, 6-year-old kid, took a gun to school and shot the teacher in the stomach, and she lived. She was charged at the state level and at the federal level. So she was charged with 2 gun crimes at the federal level, plus at the state level, 2 crimes too. And what she did was leave a Glock or something like that where her kid could get to it. So now it's different than the proximate cause issue that is talked about.
Charge them with contributing to the delinquency of a minor. Charge them with neglect of a child. Charge them with something like that. You can't charge them with involuntary manslaughter. That's my point.
And I think the answer is pretty simple, actually. And I do want to know, I covered the appellate hearing and the oral argument, and the questions that the court was asking were, a lot of them were the right questions. They were very hard on the defense as they were moving for dismissal, and they were very hard on the state also. They seemed concerned about starting a new trend that had never been started before. There was one member of the bench who was asking questions saying, isn't this really punishing gun owners? And we know that gun ownership could actually be healthy to a kid who's depressed, and you're basically, are we not sending a message that that if your kid has any sort of depression issues, that we're going to make it illegal for you to give that kid a gun, when in fact that's actually therapeutic for a lot of kids who, as far as establishing control over their lives. And so when I heard these questions, I was like, okay, you know what, they seem really balanced and fair in the way they're approaching this in a surprising way in a state like Michigan, which is, basically, woke capital of the Midwest. But I think that the answer is pretty simple here, because why are you charging the parents and not the school? The only
Bingo.
two possible reasons, there's only two possible reasons I can come up with. One is an anti-gun perspective and punishing parents who are giving or at least holding them to an excessively high level accountability that's beyond reason of being able to predict the future, which no one can do. But it's like, if you're gonna give your kid a gun, then you have to be able to predict the future as to what they're going to end up doing with that gun. Or it's an institution thing, which is that we're always about protecting institutions. You can attack the school, the education system, and that institution, or the psychiatry institution, or you can attack the nuclear family and say the parents are ultimately the ones who we're going to hold criminally liable here. And either of those bases should be something that's of concern to everybody.
And last thing, why was his bag not searched? I might have gotten in trouble a couple times at school, and you know what happened? I was searched. My locker was searched. My possessions were searched every time.
If your concern is potentially, even if it's homicidal or suicidal issues, you search the bag, right? That was the specific concern, was potential suicidal issues. He was depressed because of everything that was going on in his life. He didn't have any friends and whatever. Okay, but if that's your concern, you search the bag, right? I don't know.
Yeah. Yes, I mean, look, the kid is drawing these crazy pictures. He's brought in there because of these crazy pictures. It's like, oh, here's your bag for you. Come on.
Considering
it stretches credulity.
How simple it would have been, how easy it would have been, and the fact that it could have prevented 4 people from dying and 15 people from being injured, yeah, they should have searched the bag. I think that there was a negligence on the school's part. What are the charges? I wanted to ask. I actually don't know, David. What specifically are the parents being charged with? 4
counts of involuntary manslaughter. So there were 4 children that were killed.
Okay.
And so the theory of the case is that they essentially, due to their gross negligence, allowed this to happen.
And to get, I'm sorry. Just wanted
that's about it.
A lot of proximate cause problems there.
That's exactly where I was going. What Steve alluded to with proximate cause, and people in the audience may not be aware of this. There have been many incidents in the past where a young kid who doesn't really understand the danger and nature of guns has done something accidental where the parents have been charged. There's nothing new about that. The reason that there's a proximate cause issue, which means that, when we're talking about proximate cause, we're talking about linking the incident to the person you're charging and saying, what is their nexus there? Well, there's a concept we have called an intervening factor, which is if you have a little kid and that kid doesn't understand it, there's more of a link to the parent who's overseeing them as far as their responsibility to make sure that that kid is not going to pose a danger to himself or to someone else. When you have an intervening factor, some other force that's acting on this, that severs the proximate cause where you're much less of a factor. So in this context, when you have a teenager who has his own free will, has a better understanding as to what he's doing, no one thinks that he did this by accident. Everyone understands that he made a conscious decision that he wants to go and harm people. That is an intervening, that I'm sure everyone on this panel would agree, that should be an intervening factor where it's like, I could never predict that somebody is just going to decide that I want to go Rambo on my own school. So as opposed to, you could predict that if a 6-year-old is not going to know the dangers of a gun, or might think it's cool without appreciating that they really could be they could be killing someone or themselves, or even necessarily what death, fully comprehensible what death really means. So that's why they're much less of an intervening factor. There's much less of an intervening factor, and accountability in a situation with a really young child seems far more apropos than it does when you're dealing with a teenager who just randomly out of the blue decides to do something that nobody could have predicted him doing.
And I think even to add on that, Joe, like, it's not even just a proximate cause, superseding cause problem here. It's how do you even get to the but-for cause? How are you going to prove that but-for, if the parents had got him counseling, he wouldn't have done this? If he had gone to the counselor this day, he wouldn't have done that? How on earth are you going to prove that?
Exactly. There are a lot of school shooters, actually. Too. Sorry. There's an additional problem too, and that is the fact is that I think they're trying to hold the parents responsible on a negligence theory, and there's a culpable negligence versus simple negligence problem with that. That was the subject matter of my Kelly case that I orally argued here in Florida, and that is basically, you have to have, it can't just be simple negligence. You can't just say this. It has to be so outrageous to offend that it's and it has to be of a criminal negligence, which is a much higher standard than a simple negligence tort type standard. And that's another burden that the state, I think, has to overcome in order to hold somebody responsible criminally for the actions, for basically missing something as a parent.
Let me reframe this issue, right? Because they're trying to say that Ethan gave his parents money to purchase the gun, and the parents purchased the gun for him to use. There were Instagram posts saying, "Look at my new gun, look at my new baby," or whatever. And I take it out, and I went shooting with my mom and whatever. And here's my target and all this stuff. And they're trying to say that that is the culpability. Now let's change it from a gun to a car.
Mm-hmm.
Ethan works. He earns money because he wants a car. He gives money to his parents to purchase a car. The car is owned in their name. He says, "Look at my new car." It's still registered in the parents' name. The parents are paying the insurance for it. He goes out and he intentionally runs people down. Are they charging the parents?
Probably not.
Probably
Also,
not.
what
It's
was
the
really
gun.
interesting about the Court of Appeals
political.
decision is that. Sorry, were you?
No.
I was just saying, what was interesting about the Court of Appeals decision is that they make a point in there of pointing out that another person's intentional acts are almost always inevitably a break in the causal chain, because you're looking at A causes B causes C, like in some sort of Rube Goldberg machine. So there is an idea of proximate cause where somewhere down the pipe we're going to stop counting it because it gets too attenuated. But the problem in someone else's intentional acts is that you don't even have A causes B because someone else is making a decision. A doesn't cause B because B is an independent actor making independent decision. So one would think Ethan Crumley's decision to act, which is what they're charging him with, right? They're charging him with intentional murder, right? So he has the intent to do it. So he's acting independently. That's the entire idea of prosecuting him. So if that's true, one would think it necessarily breaks the causal chain, but apparently not so much. Apparently, these parents could reasonably foresee that he would act intentionally that day, and that is legally cognizable as a theory.
And the
which
court,
seems pretty bizarre. And the Court of Appeals isn't even really comfortable with it, because if you read their decision, they're kind of squirming all over the page.
Yeah.
And they say this is not precedent for other cases.
Yeah,
Sure it's not. Because that's not how our system works in every way.
Yeah, they're like, this is not precedent.
They
Oh, is that how that works? So it's not precedential?
because
I thought we
they
worked in a
said.
common law system.
It's
My
not
confusion.
just negligence. It's not
But
just
they said it,
negligence.
though.
It's not just criminal
They said it.
recklessness. This is this would have to be super duper double secret probation type of recklessness that they've committed here. And in those circumstances.
Well,
Yeah,
the other thing.
say that basically buying your son a gun for recreation purposes is somehow makes you a criminal, which is a lot of people, I think, in the deep blue states may think that. Well, there's a lot of, in the rural areas of this country, there's high school shooting teams that are sponsored by the school. Well, there's a good example right there.
Oh my God, there's a bunch of criminals, guys.
Well,
All planning a mass school shooting.
go after those parents.
And apparently there's something called CMP that they're affiliated with. Let's go after them too. Who runs the CMP? Let's go after them.
I like how they put the only non-white kid in the front center.
It's, always looking at race.
The joke there, by the way, for those of you who didn't get the joke, is that the CMP is a federal government program. So
Yep, it is.
that's the joke.
But but the way you read that opinion, those are three judges who want to be reelected. So
Well, it
they don't
feels
want to
very
be
much
seen as
like
the guys who said they did that by throwing out that case that would end their careers.
sorry.
Well, but I think there's an issue here, because I personally think what they did was irresponsible if you accept facts as true on the record. Now, there's no evidence that the parents read this journal about the school shooting. Absolutely no evidence of that. But just from my own dealing with firearms and having them around kids and stuff, I take personal responsibility that it's up to me to make sure they're secure and used responsibly. But Dave's point is a really good one. Is the failure of that, and then someone engages in intentional act, make me responsible for manslaughter? I mean, that issue is so touchy that, like you said, for whatever reason, the Court of Appeals said, here's our answer, and it's not precedent for anything else. And I think this Virginia case where the lady was charged with actual violations of gun laws and things relating to the children is a more responsible way to handle this case criminally. And if Michigan doesn't have safe storage law or the right law to handle this situation, if it is appropriate, do you shoehorn it into manslaughter? And that's where you go dive off the deep end on this proximate cause stuff.
Well,
and there's
prior to
also
that, we
one
do
more to
have
get into.
statutes that you could have done, like contributing to the delinquency of a minor and child neglect and things like that could have been used. And now we do actually have new legislation. Obviously, you can't touch the Crumley
But see,
parents.
is it sufficient just to, like, let's assume they bought him a gun and then it's left around unlocked, loaded, right? That to me is a simple negligence problem, not a culpable negligence problem. That's why that standard is really important. It's not a criminal act, it's a negligent act. And not everything is criminal. We want to criminalize everything. We want to criminalize accidents because there's a bloody person, somebody
Tim
that's
Potter.
killed, or there's some victim. We've got to create, we've got to assign response. We got to put a head on a pike to show the world that we're so morally virtuous.
Yes,
Yeah.
that's what Kim Potter trial was all about. That's someone that civil penalty was definitely appropriate, a civil punishment, and that's really the way we should really be looking at it. Is like, let's really peak, and that's the way our statutes are and our case law has established for centuries, is really to have civil punishment for people who screw up and criminal punishment for people who have an intent to actually cause harm.
Ironically, they probably couldn't charge her civilly because in a civil case, she'd have qualified immunity, which is a civil law concept, but not a criminal law concept. So she might have been civilly immune and criminally liable, which is hilarious.
Right? Yeah. But that's a whole government immunity issue that is left for another day.
Well, actually, that got brought up to be an oral argument when I was arguing my Kelly case, because I said, well, this wouldn't even be a civil case, in civil, because there's no damages. And they said, this isn't a civil case, counselor. This is, I got smacked pretty hard by the judges on that. So yeah, it's a different realm, but there is a point, there is a reason. It's like tort swallowing contract law. We've got to be clear on where these lines are, and not just let like the criminal system is the solution to all of the world's problems. It's not.
Steve Southern-Law, one question. I believe you grew up rural, right?
Yeah.
When did you first handle a gun?
Oh man, I can't remember that. It's too young.
Okay,
young.
so I think I was around 6, 7, something like that, and I would shoot with my dad.
Yeah.
So some of these things I feel are a cultural problem too. You have a lot of people who are from a urban area.
I used to drive to school with an M1 carbine in my truck on a gun rack.
Yeah, but when you think about the 7-year-old, and you think about the logic of this case, such as it exists, which is tenuous, I know, but if you work under the proposition that a child, as they gain older and older in age, gains more and more agency, one would assume that the reverse is true, that entrusting a child of lower and lower age that has less cognitive ability and less understanding of things is inherently more reckless. So entrusting a 7-year-old with a firearm under any circumstances would be presumably inherently more reckless than trusting a 13-year-old with that same firearm under those same circumstances. So you could actually use this case under that logic to make the therefore correlative argument that entrusting a 7-year-old with a firearm is in and of itself inherently reckless, so that if your 7-year-old does anything with it, now you're criminally liable for that too. Fun and exciting times had by all.
Yeah.
Well, coming from way out in the country where one of the fun things was drunken laughter and gunfire, at age 7 to 9, and you're handling a firearm, you might be one of the most responsible people that weekend handling a firearm because there's a lot of alcohol and a lot of guns. And when I grew up, I learned the hard way from personal experience that those things don't mix.
I believe it.
I just want to point that out because I think a lot of people judge these cases at different levels. And, I grew up, a lot of my friends would go hunting. Okay. I mean, sorry. Yeah. I go hunting with dad and whatever. And I have the gun. And by the way, I had access to the guns all the time.
It's like you guys were raised in a different country from me.
We were. And that's why there are 50 states, Joe. Yeah. We
by the way, I'm envious. I'm not saying that in any sort of way as a put down. I'm like, I grew up in such a different world where it's like, I don't think I knew a gun owner until I was in my 20s. Like that's how different the Northeast is compared to the Midwest or South.
We vacationed in West Virginia, and I remember where it says I was there for Thanksgiving, and we were having dinner, and all the little kids, I'm talking about like maybe 10 years old, maybe 12, all were marching away. They had their orange hunting and they had their rifles and they were going out hunting. There's like 5 or 6 of them walking into the brush with their hunting rifles, and they were ready, and they were Trump. There was a few older kids to keep the littler kids. It was amazing. I was like, this is America. God bless America.
Well, the separation between the city and country may not have been as disparate in the past, because famously Justice Scalia, when he was schoolboy Scalia, took a rifle with him on the subway in New York to go to his shooting classes at school, and it was legal. So I don't know, it's maybe a relatively more modern phenomenon where this disparity exists.
Yeah, fully automated machine guns were illegal too. I mean, Tommy guns, all of these things as we go back through time, Kurt, right?
You could buy guns at Sears.
Yeah. Oh yeah. Oh, well, Walmart. I don't remember if they're still selling them or not, but they've been selling them forever.
Yeah, I think they're still selling them at Walmart.
I don't know if you buy guns at Walmart. You definitely get ammo at Walmart.
Yeah.
Chandler, can you buy a gun at Walmart? Do you know?
You can, but you're asking me for a specific reason, which is that I've never been to a Walmart, and everybody makes fun of me for this.
She's in LA.
You're better off. You're better off.
But I remember that was the subject of Bowling for Columbine, and it's funny because it's there was that case in Michigan where that 6-year-old shot his classmate.
Yes.
And it happened in I believe, in like the early 2000s. I keep thinking about that as we're discussing this, just specifically because it happened in Michigan. I think it happened in Flint.
Well, they didn't charge the parents, right?
I don't recall. I know that I believe
maybe
that it was,
they can. Is that statute of limitations run yet? Maybe let's give it a go.
A good question. I don't know. It's a challenge.
Just so many bad implications. But so their trial presumably will go like November, December, or maybe even January for the parents. But it's right now it's with the Michigan Supreme Court. However, our Supreme Court has a tendency to want things to play themselves out in the lower courts. And so I don't have a high hopes that they're going to make a decision on this that's favorable to the parents. And this is probably going to get kicked back down and go to trial. So that's where we are with that. But right now, it's just Ethan, the actual school shooter. He's got some hearings right now regarding his potential sentencing of life without the possibility of parole. So that's what I've been covering.
So
what I was going to say, Joe, you were on yesterday. What's interesting is that the cop that was on the stand is underplaying the parents' involvement, because there was a lot of cross-examination by Ethan's defense team, trying to put the blame on the parents. And the police officer's like, no. The parents were, they got a phone because, advice of their counsel. And they didn't abandon their vehicle. They had 2 vehicles and they took 1 vehicle and things like that. That very same cop, I guarantee in 3 months' time, is going to be testifying extremely differently.
The funny thing is,
you know what? Hopefully they bring that same cop back, because they can use his own testimony against him.
Yeah, his testimony is locked in now. That's yep. He can't walk it. Well, he could try to walk it back, but then
it's gonna be hard. It was very deferential to the parents, or in the parents' favor, I should say. But it was just interesting, and that's why I'm covering it, because they're locking people in the testimony, and you kind of get a preview of some of the exhibits that they're going to use. They went through a lot of his journal and things like that yesterday, and so it's very interesting.
This is a great super chat. This is a really great. This is a phenomenal question.
Yeah.
Even though it's not precedential.
And the funny thing is, for where David lives, that county, there's a rural part, but then you also get into the buildup of the Detroit metropolitan area very quickly. And Detroit is got a lot of problems. And how long till some moms of a gang member are going to start facing issues going forward?
Well, that's the exact issue.
If he was in a gang, why didn't you stop him?
Mm-hmm.
I think the mass shooting aspect of it is probably what tips the scales on that. Usually in the gangbanging community, I think they'll maybe do a drive-by, but they tend to have lower numbers and they're more specific. And they accumulate over time.
They will, but it's generally when you start using these laws and you start trying to push these theories, they end up kind of blowing back onto, especially with guns related, ends up disproportionately affecting minority communities a lot.
Oh, so of course.
I see that going going
And it
after
tends
them.
to be black victims and black assailants, which is why no one on the left actually cares. So,
With all due respect to the Court of Appeals,
only certain Black Lives Matter.
All due respect to the Court of Appeals with their non-precedential decision, that just this one time, it's only this severe, it's this important. We'll never do this again, says the state. We'll never use this power ever again for any other case. It's ever less important than this.
I mean, it's
just this
fascinating
one
'cause
time, though.
The question
Right.
That's definitely how that works.
Kurt makes a good point there too, which is that this is to me, that is not the role of the appellate court to make individualized decisions. They're supposed to make broad-based rules that apply to everyone beforehand, that we can apply fairly and equally to all people that come before the court. To go down and say, we're going to bend the law for this individual case because we don't like this individual fact pattern is exactly what they should not be doing.
Yeah, they're making very bad law and trying to avoid the implications of that. But the practical reality is the cat is out of the bag. Like, you don't have to cite the case as precedent to authorize it. It's been allowed to go forward. We know it'll be allowed to go forward in the future.
They clearly know the bad implications. It's all over the page. They're absolutely squirming on the page all over the place because they absolutely realize
it's actually
bad
it's habeas
this
corpus.
is.
It's habeas corpus. It's like we're only going to punish these people and no one else. It's as if
it's a bill of attainder.
Bill of attainder, yeah.
It is. Yeah, it's as if,
See,
it's as if the judiciary is basically taking a legislative role that we have the ability to punish. That the law is that we can punish these parents and nobody else. That's what's happening, and that's because there's this gut reaction that a particular case that makes us feel a certain way because we're so outraged about it. So we want to implement punishment because we're all riled up about it, and we lose. That's exactly what the Constitution didn't want us to do. Where we're going to isolate and say, I'm going to make rules for this person and different rules for that person. It's really showing an unshackled. You're unshackling yourself from the responsibility of the decisions that we're making at the upper levels of government or judiciary, when you're basically saying, I'm going to try and punish these because I don't like them, but I pretend that doesn't have any other ramifications, even though ultimately invariably it does.
Well, what I'm thinking isn't Thomas Binger kicking himself watching this case going, I should have charged Kyle Rittenhouse's mother for driving her son across state lines. That's all I've been thinking this entire time.
It is surely not too late to charge the mother, and that has got to be within the statute of limitations. So don't give Binger any ideas.
I hope he's not watching. Fluffer Boy 2004. If you're watching this, don't get any ideas.
And that mob mentality is what happens when you have leadership, which is basically all about getting approval from not being a real leader, but basically whatever is popular. I'm going to stand in front of the crowd and implement what the crowd wants rather than lead the crowd toward a healthy direction.
All right. Speaking of public pressure and coverage, etc., let's go on to Brian Koberger. Andrea, I think you've been.
Is anyone here really covering that? Because I don't think anyone here has really been into that case.
Let's talk about the alibi.
There's someone in the chat. There's someone in the chat named Andrea Koberger.
That's rad.
I saw that.
Yeah, so I mean, lots of stuff got filed in Koberger this week. The alibi, non-alibi was one of the big ones. He filed his response to the state's alibi demand, but didn't really give any of the stuff that the rule says you're required to give with an alibi, specifically the witnesses who will support you and the locations of the places where you claim to be. Basically, she just said, we're reserving our right to elicit that kind of thing from the state's own witnesses and potentially present expert testimony on it. But the state clearly is not satisfied with that response because they have now filed their own motion to compel, basically, demanding that she comply with the statute or not be allowed to present evidence. So what this is really setting up is a bit of a constitutional tete-a-tete because the problem is that on the one hand, you have the Supreme Court saying it's perfectly fine for courts to adopt discovery rules to keep the process orderly, to prevent one party from being able to sandbag the other and lie in wait with something that the other side isn't going to be prepared to respond to. We don't do trial by ambush here, so it's perfectly okay to have rules to prevent that. on the other side of the equation, though, the defendant has a constitutional right to present a defense. You can't just arbitrarily say, no, you don't get to put on this evidence, even if this evidence, would tend to show that you're extremely innocent. So that comes up in situations where you come up with evidence later in your investigation, or, somebody comes forward, you discover something you didn't previously know. A lot of those cases, in fact, there's one specifically out of Idaho with a late discovered witness where the trial court had excluded it, and the Supreme Court says, no, you can't. You have to look at what's the prejudice to the state under the circumstance. You have to look at what is the diligence that the defendant exercised to be able to get that information and so forth. So the way I am reading all of this is that he doesn't have a conventional alibi that you and I think of in the sense of, I was over at, X bar with so-and-so drinking beer and, from 9 p.m. to 12 p.m. And so I can present a witness, I can give you my receipts, maybe I'm on camera, coming out of the parking lot. He doesn't have that type of evidence. If he did, he would disclose it, because that's compelling. That's exactly what you would want to have in that type of situation. So I think what we have is more of a situation where he's potentially challenging either the state's ability to put him in any particular location, which at this point, all we know about is the ping evidence and the video of the white car that an FBI guy, first said was one type of Elantra and then later said was another type. And we don't know the timing of any of that. So basically just denying that any of that is him or can place him accurately at King Road. Or on the other hand, because the timeline of these murders is so extremely tight under the state's theory, it had to have happened between like 4:10 and 4:30 in the morning if Brian Kohberger in the white car is the person who committed them. And so if the defense can present some evidence that is not when the murders took place, okay, the murders actually took place like 2 hours before that or something, then you're still in the same situation. It doesn't matter if Brian Kohberger is out there doing a U-turn, on King Road at 4:30 in the morning. He wasn't there at the time of the murders. So it's just because alibi in general is this kind of broad concept. You weren't there at the time. He can potentially challenge the you weren't there. He can potentially challenge the at the time. He just doesn't seem to have any affirmative evidence of his own at this point that can definitively establish a challenge to either one of those.
How are you feeling about the case overall? I mean, just in the bottom line, do you think they got the right guy, but he's got some pretty good defenses? Or do you think there's some real questions whether he even did it?
For me, based on what's public record at this point in time, I have a lot of questions about this case. It looks very precarious to me. The strongest piece of evidence is this touch DNA, a single sample of touch DNA that's on, the button of the knife sheath. We know very little about the rest of the circumstances. The defense characterized the knife sheath in one of their latest filings as being placed under the victim. I don't know what that means. I don't know if that means that maybe one of their first responders found it and stuck it there. I don't know if it means that the killer potentially, stuck it there. We don't even know. Yeah, we don't even know if a K-bar knife is consistent with the murder weapon, so we don't even know if there's links between these things. So the single piece of DNA, and then that is strengthened by the circumstantial case that they've built of white car in the neighborhood, which towers the phone is pinging off of, and that type of thing. But, if there's no connection to the victims, like the defense said, no evidence of any kind of DNA transfer into his car, blood in his car, things like that, it just creates a very improbable, to my mind, theory of kind of the mechanism of these killings, how this could have happened consistent with the way that the state describes it. Not saying it's impossible, just one that I think is difficult to prove.
I got to get going, but I do want to push back on Andrea a little bit because she is covering it and she is the go-to person, I would say, on this case. And I'm really looking forward to it. But I would just say it's premature to put too much in that basket about what the state has and what they don't have. we're basically reading tea leaves. The Idaho police and the prosecutor's office have been very tight-lipped about their evidence. And so we don't really know until we see a trial, and we're sorting out. Now, I also think that you have this DNA, and there's some questions about the DNA processes on that. But if it's on a K-bar sheath underneath the body, that K-bar must, it's like, and the murder weapon can be connected to a K-bar. And there is a white car in the neighborhood that matches his car. And there's his cell phone is in that area. It's like, well, it's maybe a tight line, but that means there's a window of opportunity for which he could have done it, which these circumstantial evidence wrapped around the DNA makes for a stronger case. And we don't know about the other evidence. So I would say that it's a little premature to judge. And I'm going to push back, and I have to head out.
If the knife was placed, dismiss the case.
I will defer to Andrea in all things Kohlberger, because you are doing yeoman's work there, going to court and following everything, and you have an excellent perspective. So thank you for it.
Before you leave,
well, my pleasure. And I actually don't disagree with anything that you've said at all. In fact, I think that's one of the challenges of this case is the fact that we knew as soon as he was arrested that the bulk of the investigation was really just getting started. And so what we knew from that probable cause affidavit, it's clearly enough to charge. And in my perspective, was it ever going to be enough if that's all they had to get a conviction? That's where the questions start to come up.
Well, I have a vested interest here because, Brian Kohlberger is my alibi. So I will say that I've got to get going.
Thank you. All right. See you both.
You told me, Andrea. I got to get more on top of this case. I need to know more about this.
It's a very interesting case. And so just the more that kind of comes out about what may be there and what may not be there, and kind of the questions that are being asked, it really is painting a picture of, at least to me, a possibility of a rush to identify somebody. I understand why you would do that. DNA on, a potential something related to the murder weapon. Yeah, that's going to be something you can't ignore. But it just creates some questions. It opens up some questions about to what extent have they allowed the evidence to present itself, the case to unfold naturally in a direction towards a specific suspect versus, okay, we found this one thing and now we are coloring everything else that we look at in the case and potentially distorting our perspective on the evidence in order to confirm this initial suspicion. Oh, it must be him because of this DNA on the knife sheath.
Right, because the implication is that, if they have blinders on and there is maybe somebody else out there that they just decided it's got to be this guy, then that is a danger to the public, because that is a very dangerous person who committed that kind of a crime. We don't know if that's a serial killer. We don't know if they could strike again. The implications are dire and enormous, which is why, police departments who frequently have blinders on need to be more, so if we had something like a receipt for a K-bar knife, and we could confirm that he purchased it, maybe that could lead us in another direction. I haven't seen the lynchman. I haven't seen the smoking gun, the thing that
it's all under seal though.
Ties him.
All of that stuff is under seal.
It's under seal.
Right. And of course we have to wait and find out what the state actually has. Maybe they have a lot. I don't know yet, but I just haven't seen anything.
I'm going to say this. If they had his DNA on that knife sheath, which they do, now how it got there, DNA is circumstantial evidence and it's subject to multiple explanations. There's such a thing as secondary transfer and all of that. And they have this circumstantial case. They don't arrest this guy, and if he's the guy, and he goes back to Pennsylvania and stabs 3 more people, there will be a giant outcry over that because they have probable cause on this guy. Now, that's not the same thing as a case beyond reasonable doubt, but they have probable cause. And, I think they got the right guy. But I will say this about the alibi that Andrea explained is, irrespective of whether he has one or not, if you're a single guy, which he was, you're living by yourself and a crime occurs, say, between 2 and 5 in the morning, it's going to be hard to have an alibi other than your phone was there. And, maybe your phone, you left your phone to go commit the crime. So while I think they got the right guy, and I like to dunk on it a little bit that there is no real alibi there, also, he doesn't have to have an alibi to be not guilty or even innocent. And I think it would be unlikely to have an alibi unless he was camping with his friends or with his family or something. So to me, that's a little bit of a non-starter to dunk too hard on defense for not putting up a real alibi because he's a single guy who lived by himself.
Yeah, most people who are single would be at home asleep.
Yeah,
that's not an alibi.
So how are you going to have an alibi, when the crime occurred in the middle of the night?
That's why I have like 12 security cameras around my house, trained on my car and on me while I'm sleeping.
One
and
question.
so then I see Rob also is in the chat, and he mentioned the other interesting thing that got filed this week, which is Ann Taylor, his defense attorney filed a motion to dismiss the indictment. And it's a very interesting argument that she's made. Basically, the claim is that under the Idaho Constitution and under this long line of kind of common law authority out of the U.S. Supreme Court and other places, that an indictment to a grand jury has to be proven by proof beyond a reasonable doubt. And what happened is that Idaho then adopted a statute.
Really?
Yes, that's
Beyond
the
a reasonable
argument.
doubt?
Oh, I'm going to
Yes.
have something to say when Andrea's done on this one.
This is the argument. And then Idaho then adopted a statute. The legislature adopted a statute that says that for an indictment to be returned, the grand jury has to be persuaded that the evidence is such that a trial jury would find him guilty. And so she's arguing that's basically the same thing. If a trial jury is going to find him guilty, they're only going to find him guilty beyond a reasonable doubt. So the statute is saying the jury has to find the evidence beyond a reasonable doubt as well. The problem is there's a conflict because the Idaho criminal rules that set out the standard and are the basis for the instructions that the grand jury is given, rules that are adopted by the Idaho Supreme Court, incidentally, say that it only has to meet a probable cause standard. And of course, people that practice in indictment, grand jury jurisdictions, which I do not. Washington does not do grand juries, so this is not really my thing. But most people that I've seen that practice in those jurisdictions say, yeah, it's a probable cause standard. That's pretty much the norm. So it is this very technical and interesting historical argument that she's making that appears on the face value. I haven't dug into all of the sources and stuff yet, but it does appear on its face value to have some kind of logical merit to it. The difficulty that I see with it is that it's the type of argument that has pretty much no chance, in my opinion, at this stage of the process, because Judge is not going to say the Idaho Supreme Court messed up when they adopt the Idaho criminal rules saying that the standard is probable cause. They would have known all of this stuff. They would have figured out all of this history. They would have had all that in mind when they decided how the grand jury is going to be instructed. So it's not going to be his place to be the one to say, yeah, you know what, Supreme Court, you're wrong. I think there's a very low chance of that. I think what's really going on here is that Brian Kohberger is raising this issue because he has to raise it to preserve it if he's going to want the Idaho Supreme Court to then go ahead and take a look at it and reevaluate their own rule. And because they're the ones who would know, hey, were we thinking about any of this? Did we actually get it wrong? They will sometimes admit it when they get it wrong. It's not unheard of. So it's a very interesting motion from kind of an academic standpoint, but in terms of practical litigation, don't see this one really moving the case one way or the other. It's just something they're preserving for future appellate review.
Kurt, let me read you this one sentence from their brief, consistent with everything Andrew said. This is from the defense's own brief, and it goes right after what Andrew said.
I know exactly what you're going to say.
They say, that said, the defense recognizes that the whole of modern jurisprudence on this issue is against it, as well at least one founding father is a state. Now, they're doing the right thing since they're presenting this not just to everybody on the planet who wants to read it, but to the judge. So the whole of modern jurisprudence is against them because states aren't going to adopt beyond a reasonable doubt for grand jury. So I agree with everything Andrew said. I don't have any heartburn with defense filing this, but this is no winner here.
Yeah.
Well, I appreciate the attorneys doing that because that's ethically required. You have to bring contra authority to the attention of the court. And when it's this contra, it's like, yep, everything is against me, but let's say that I'm right anyway. But
the
it's
whole
like
of modern jurisprudence.
And a lot of times you're doing that though with issues of first impression. For a long time, all of the modern jurisprudence was not in favor of Heller. But we still got it. So these things do change and evolve, and people go back and reevaluate the historical record and all of that. So it's not a frivolous issue. It's not a completely lacking in merit issue or anything like that. It's just one that it's not really the place for judge to decide. It's for the Idaho Supreme Court to decide.
Now, Andrea, they do have, because I don't think this is a winner, but having said that, didn't they also file something under seal that would be about the selection of grand jurors that may be more mainstream merit that we just can't see because it's sealed?
Yeah, and so the last thing that got filed was another challenge to basically this one is just asking for more of to extend the stay that Judge has already granted for 37 days to kind of prepare the grand jury proceedings and give the defense time to review that and evaluate if there are any challenges. And so she's filed basically saying there are specific statutory requirements. It appears they didn't meet them, but we don't know what the details of that are because she included all the specifics in an affidavit that were filed under seal. So there's really no way to evaluate whether there's any merit to that or not, or where it will go, because we don't know the details.
As long as the attorneys are trying something bold and new, let me give them another idea. Here's another trick for you. The Supreme Court recently, of course, in Ramos versus Louisiana, said that juries at trial have to be unanimous. Mm-hmm. If a grand jury has to come to the conclusion that a jury will convict, mm-hmm. maybe that implies under Ramos the grand jury itself also has to be unanimous. Mm-hmm. So maybe we need all 21 of them to agree to proof beyond a reasonable doubt. Why not throw that in there while we're at it?
Good one, Kurt. I love it.
Any of you covering Sam Bankman-Fried?
I haven't looked at that in months.
I just heard they dismissed the charges against Bankman, right?
Yeah, he just walked. Yes.
Yeah. Did he walk, really?
Yes.
Yeah.
Yes.
Because the federal government has decided to honor a treaty between us and the Bahamas. Right? Or,
they just dismissed the one charge.
Right, but a pretty major one.
Serious charge.
Yeah.
Well, the campaign finance violation, I mean, I don't know if it's the most serious charge. It's okay. So they dismissed the campaign finance charge.
Well, which coincidentally would have a plethora of wonderful discovery, wouldn't it? Mm. Isn't that a nice charge to dismiss? I mean, if we're going to look at all the charges out there and people who could be affected, I would think, maybe that would be the charge I would be dismissing. Or am I just too conspiracy minded?
Makes sense to me.
Conspiracy minded usually just means that you're 6 months ahead of the news. So,
yeah.
All right. Well, if you
guys I don't know anything about the friend.
Oh, God, what was it? There was some weird stuff about her. I haven't followed it that much, but I'm guessing that since you guys haven't really covered that, somebody here has been covering Sarah Boone. I think Steve Southern Law, right?
Yes, I did.
What's up? What's going
on?
So,
wow, way to break it down there.
It's like, there we go. I bring up for the scintillating long commentary.
She has so many weird things going on, but here's the latest weirdest things. So her attorney has found, I was calling, is there a Dr. Bozo out there? So she wouldn't want somebody to support battered spouse. She needs an expert for that to establish a self-defense claim for putting this guy or leaving this guy in the suitcase. And they said they couldn't find one. Now they have found one that's $400 an hour, and they want the court to approve it. And the JAC, which is the committee, the whatever organization, state agency down there that pays for this, says, wait a minute, we already paid for a mental health expert for her to do this. We paid about $7,500. We already did this. This would be a new additional expert outside of our rates. So she has already had an expert, I suppose, didn't support this battered spouse thing, and now she's found somebody who would. So there's a question of whether she's expert shopping and the court would really order this to occur, because to me it's utter nonsense. But then she also, in her pretrial conference, when they were talking about this a little bit, her one question to the judge was, why is my new letter not on the internet? I need everybody on the planet to be reading my letter.
I read it. It was glorious.
It was glorious. It was definitely her letter. She's a very Rain person, Wapner at 5, with a lot of details on numbers and things. But the main theme is what a victim she is. And if people knew her truth and wouldn't rush to judgment, then they wouldn't see her the way they do. But even though she's written like 500 million letters, each one 500 million pages, Wapner 2.5 billion pages of stuff, her truth never comes out. She's never telling anybody, well, this is what actually happened. So she's mad at you for not knowing what happened, but she won't tell you what happened. But what her attorney is desperately trying to do is establish battered spouse defense, which in Florida you can. And I certainly believe in that defense. But to me, it's inconsistent with the interview she gave with the police and interrogation. And also the fact that if you're afraid of this guy and you get him into the suitcase, do you really go upstairs and go to sleep? I mean, it's one thing if you shoot the guy in the head late at night because he's threatened he'll track you down and kill you and all that, but you leave him in a suitcase where he may escape, and then he's going to be even madder. So it's just stupid. She was drunk. He was drunk. She left him in there. She probably didn't mean to kill him, but she definitely wanted him to be uncomfortable. Either way, it was reckless, and she wasn't afraid of him. Whether she was a battered spouse.
Taunting him?
She was taunting him in the videos, Yeah,
Yeah,
so
you do that with the guy who's going to later on cause severe damage. That's exactly the way you handle it.
I mean, you leave him in a suitcase where he might come out, and then he's going to be
you
super
mock
stoked. So,
him, and
so this doesn't, to me, sound like battered spouse defense.
I did a dual stream with Chandler the other day where we read through the letter. And what's interesting is that all of her prior letters, she was mad that they were being released. This one, she specifically wanted released, and it almost read like a press statement, right?
Exactly.
So it was interesting. I will say that she's probably smart for not coming out and giving her truth in a letter, because that absolutely will be used against her. So she's smart in doing that. She's just basically saying she's complaining about her attorneys and not being, informed on stuff, and then saying you just need to all be understanding, and my truth will come out. It's weird though. She's just weird.
I look forward to her taking the stand. That should be fun.
I reached out to the court to get access to the live media pool feed, so I didn't have to rely on others. And they said, sure, fill out this application. And I said, okay. And it was this long, lengthy thing. So now I am actually media certified. I am considered a member of the media with the court. I get a press badge and everything. And then I asked Steve Gosney if he would go pick it up for me since he's down there. And he's like, sure. So I've actually added him as our senior court reporter. And so I can get him a badge too.
This means you can copyright strike everybody out there.
That's right, damn it.
Wow.
So that's fun.
That's amazing. Do you have a press pass for Koberger yet, Andrea?
I do not. There has not been any need for that so far. And I'm, kind of a little bit contrary in that I would throw a fit if I were required to get a press pass to get a seat in the courtroom, so no, I have not and will not.
Are you planning on live attending the trial?
Yeah.
Oh, awesome.
Oh, absolutely. Yeah. I'll be back. There's a bunch of hearings
look forward
now.
to having you on my channel when I'm streaming that trial.
Oh, yeah, I'd be happy to, Joe. I've actually been to every hearing so far except for the very first, the preliminary appearance. I had to be in court, so I couldn't go to that one. But I've been to all the rest of them. The next one that's coming up is on August the 18th. There's several things on the docket. One of the ones that's, of course, very interesting to me is this investigative genetic genealogy that the defense is trying to get access to that through discovery. The state is saying, no, it's not relevant because we're not going to use it at trial. The defense is saying it's relevant to show that you targeted our guy and then reverse engineered your investigation, to come after him. So that one's going to be fascinating. A whole lot of other things, preliminary things on the docket. So I will be there for that one as well.
Wow, amazing. Okay, so let's go to something less contentious. Mitch McConnell had an incident yesterday. I am curious about this, and I'm not getting into the politics one way or another, but he's the Republican, you've got Feinstein, the Democrat. Is it time to maybe shuffle on a little bit? What are your thoughts?
Joe.
Yeah, I think the best explanation I saw for what happened is that he had a seizure. So that seems plausible. But I think in either case, there's a lot of people who are not with it in this world anymore.
Absolutely.
So, yeah.
If God wants him, who are we to deny God?
Well, I want people who are representing the country that are competent.
Yeah, I mean, I remember, when they used to show the Politburo and the guys out there barely able to wave, and they were just figureheads and brain dead and stuff, and that was supposed to be why we're better, because look at the Soviet Union. It's all nonsense and figureheads and fake government. And now you look at McConnell, Feinstein, Biden, and some of these other people, and you're like, who's really pulling the strings on either side? Who's really pulling the strings?
And that's the whole thing. Doesn't it just speak to the brokenness of the system, that it doesn't even matter which puppet is standing up there at the podium, in front of the cameras? It doesn't even matter. They're completely fungible. The real decisions are being made by unelected people behind the scenes. And so it literally doesn't matter if somebody, at high levels can't function in what is supposed to be his capacity in front of millions of people.
Now, I know the Republicans have taken this up on Biden and his incapacity, and I'm really thankful they're not supporting somebody who would be in their 80s if elected to a second term as president. So that's good. So this is a multi-party issue, I think, of whether we really want competence or what are we actually after here.
Yeah. I don't know. I'll push back on that a little bit. I don't think that age is necessarily
It's not the age; it's the competency.
No, I'm pushing. I am pushing back at Southern Law here, who seems to be taking a not so veiled swipe at Trump's age. And my point is, I think that, you know, if someone has competence, they have competence. Someone could theoretically have competence into the triple digits. But when we see those signs of decline, then to start signing them up for a multi-year contract seems kind of crazy. I mean, so I can understand that. But if someone is not really displaying any kind of signs of decline, in that case, I think that we're depriving ourselves of potentially having the best person for the job.
Joe,
But I think the
you're
reality
right.
is that the system isn't about getting the best person for the job anymore. And we all know this. I would flip the coin to the other side and say, look at what's happening with the federal courts and the court appointments. When you have lifetime appointments and that system has become politicized, what's your incentive? Your incentive is to appoint the youngest people you possibly can so that they will be on the bench for the longest. And so you're not concerned about what type of record have they gathered, what type of life experience and judgment have they developed. No, you're just putting a political placeholder in there to sit on that bench for you for as long as you possibly can. So that is the problem. The focus is not on competence at any level in our government anymore.
That's definitely true.
My hearing is back up and running, so I'm going to jump. But Eric, thank you very much for having me. Everyone, Southern Law.
David, great seeing you.
Good seeing you guys. Kurt, take care. Have a good weekend if I don't talk to you all.
Right. See you next time.
Perfect. I figure I'll be closing out in just a few minutes anyway. Last thing I had written down is just something that came across Twitter this morning. I saw RFK Jr. has been refused Secret Service protection. And out of everybody who's a candidate, first off, you have the question of, is he a viable candidate? Well, his numbers show that he is a very popular candidate, very legitimate, percentages that make him viable. There's another little problem that, let me see, his uncle, his father, both of them.
What are the rules on this? Because I was under the impression that it's a little premature for that under the rules. Am I mistaken? For him to get Secret Service protection?
Well, according to the tweet, and by the way, I swear there's some people out there who are like looking for numerology and things, no matter where it is. I guess he put out that normally the process takes about 14 days to approve, disapprove, or whatever. And he didn't hear back for 88 days. And somebody said, oh my God, that was supposedly a white supremacist thing. And I did look it up and I guess the number 14 and the number 88 are very bad things that people are never supposed to use. And there are a lot of people who are always looking for something. I had to literally look it up and I'm like, okay.
Don Allen and I agree. It was for nominated candidates. That was my understanding. It seems way premature for that. So I'm not surprised he was denied.
I'm not sure. What happened last time? Because I think there was Secret Service protection for Bernie Sanders. He wasn't nominated. He didn't make it through a primary. So how did he warrant it? I'm just curious, using that same logic. Plus, RFK is a special case. The optics of this are awful. He had a 67-page comprehensive report, obviously, because there's a little bit of a history there.
Well, what it suggests to me is that when Kurt's saying that if it's for nominated candidates and then he submits a 68-page report, maybe it's automatic for nominated candidates. But if you're pre-nomination, but you can establish some kind of danger or something, then they would approve it. And that's why maybe Bernie had it or whatever. Who knows?
It could be. And again, I don't remember the exact reasoning why, but I know that they did give it to him. And then I'd have to look at the 2020 election. I think there were multiple candidates who had Secret Service protection during primary season. Members of the Illuminati automatically get it. Well, yeah. And if you're not in it, then you have to use the secret code words to get in there. But I don't know. Well, somebody is saying maybe because Bernie was a senator. I guess I don't know. But some people say he doesn't deserve it because some things he said may not be actually correct.
And we certainly know that the president we have and the one we had and all the candidates, they never said anything incorrect. So.
Scrupulously honest and direct about everything. Always.
Yep, I like it. Bernie had socialist security. That's a good one. All right, so nobody really has any thoughts about that, I guess. I'm
trying to look up the regulations for when Secret Service get appointed to protect someone. It's not like something you can find really quick. I mean, there has to be some sort of guidelines, right? I mean, we know the president and his family are going to get it, and vice president, but
right.
I think the point to Secret Service is to spare us the embarrassment of like what would happen if some foreign agent decided to kill this person. I don't think we tend to worry about domestic threats, although a lot of people, including our president, seem to be more concerned about domestic threats than foreign
well,
threats.
Gee, then who was convicted for the previous 2 assassinations I just referenced? Were they foreign threats? No, they were. Only
in fact, every attack on a president, every attack on a president has been domestic. Yeah. Going all the way back to Lincoln. I mean, it's always been domestic, or Reagan. It's always domestic. Although
Hamilton.
Dan Bongino is saying he's supposed to have a detail, and that guy is former Secret Service, so he might know. I don't know.
Yeah, he would know better than I would.
And he's also a right winger, so it's not like he's a big fan necessarily of a Democrat. So very, very. Oh, here we go. Secret Service is authorized by law to protect major presidential and vice presidential candidates and their spouses within 120 days of a presidential election,
which is not for quite some time.
Yeah, but that's a bare minimum. That doesn't tell you who it gets expanded out to.
Right.
So,
and Bernie was covered before 120 days because the primary usually happens about what? How far ahead is the nomination before the actual election?
I think the first ones are like in February, aren't they?
Oh, that's the primary and the caucuses. And I think they're January. Anyway, whatever. We don't even know where they're going to be. But I'm saying, when is the person actually nominated? It's usually in the summer, right? So there's 120 days would imply that it's the nomination. And if these people had it during the primaries, that's more than 120 days.
I sent you the link from secretservice.gov about their coverage. So if you would just want to share that as far as who they're authorized to protect, that might be helpful.
Absolutely.
That might be informative.
It's helpful to know what the rules are if you figure out that there's a problem or not, right?
No.
Well, come on, I'm a YouTuber. Why
I can ask for Secret Service protection. They're probably not going to give it to me.
I can share my screen if you want.
Yeah, just take me a minute, dude. Sorry.
Right.
Okay, 1901, McKinley.
You might want to make that bigger, just like so you can see it better.
I can't, it's already first a crappy page, dude. I can't. I got to work with what it is.
Who would think the government would have a crappy webpage?
Oh, shocking! I know.
They want you to take a long time to read it while they're tracking you.
Yeah, right. Got to get all those cookies in place.
To all our friends at the Secret Service, hello. Welcome to Lawgic.
We love the Secret Service.
Happy Friday.
But they say that the Secret Service is authorized to protect the president, vice president, or other individuals next in order of succession to the office of president, president-elect, vice president-elect, immediate families for the above individuals, former presidents, their spouses, except when their spouse remarries, children of former presidents until age 16, visiting heads of foreign states or governments and their spouses traveling with them, other distinguished foreign visitors to the United States and unofficial representatives of the United States performing special missions abroad, major presidential and vice presidential candidates and their spouses within 120 days of a general presidential election. That's that 120 days. That seems kind of all right. That's maybe why Bernie got it. Yeah, it's too small a number. 120 days. That's a very.
That's a ways down the road.
Yeah.
Right. And by the way,
4 months. So that's
he cited his father,
which is what, September?
Yeah.
July?
He cited
August, September, October, November. Yeah.
By the way, he cited his father's assassination as the reason this coverage was extended, because his father was assassinated like in April, I believe. I don't remember the exact date, but again, he was a primary candidate. He was not the nominee. His father was assassinated before that point.
Mm-hmm.
And that's why supposedly they authorized it. So look, correct me if I'm wrong, the optics, I think, are very bad.
Yeah.
Out of all candidates, you're going to refuse protection. You're going to pick the one who had his father and his uncle assassinated, and probably the most popular in-party candidate right now in terms of Democrats when the sitting president is a Democrat. This looks awful.
Now, let's say he's not entitled to it. It's still good to make it an issue right now because it does seem so legitimate and it gets his name in the news a lot. So nice job by his campaign.
Absolutely.
If in fact he isn't entitled to it.
Absolutely. So, all right. Well, folks, on that point, to wrap it up, Stephen, and you know what? I want to get this out. I'm terrible about saying this, but please, if you like this kind of panel, hit the subscribe. You do it every Friday. Have amazing, amazing people. I'm very fortunate you guys are coming here and sharing your wisdom, etc. Even Joe and Steve. What do you have coming up?
So the Supreme Court recently issued a decision 9-0 that everybody should subscribe to Eric's channel. I will get that out there because I don't think we covered it. But if you want to see my summaries of cases, you just go to Southern Law and you'll hear it with this accent from Brooklyn.
All right. And you can, by the way, everybody's channel is linked in the description. I'll have to update it for Kurt. Sorry. And you just click that, follow right through. It'll take you right to the channel. Andrea, thank you so much. What do you have coming?
Yeah, well, so I have a lot of my own work coming. Unfortunately, I have been really, really swamped for a while, and I have not been able to put out as much content as I would like. However, I am going to continue talking about Brian Koberger developments, of course. And then the fun thing that I'm so looking forward to is that we recently got access to the full trial transcripts from Depp versus Heard. And so that means all those sidebars, all those sidebars that we wanted to see at the time that we weren't able to, they're out there now. So yes, I have been reading through all of those and trying to find some of my favorites and working up some breakdown material for that for you as well. So hopefully going to be able to put something like that out soon.
Awesome. Kurt, what do you have coming up?
Well, speaking of transcripts, this afternoon, currently scheduled at 2 p.m., I will be reviewing the transcript of the Biden plea deal hearing that recently occurred in Delaware court, as you will know. And remember, Biden, the child, who was 53 or 54 and just a derelict youth, don't you know, was supposed to plead guilty in response to a plea deal. But the judge went on for about 3 hours, I'm told, in the discussion about this thing because the judge was confused about exactly what the deal was. And apparently the Department of Justice was potentially hiding what the deal was from the judge, right? Like what it said on the plea deal is you're going to only plead to this gun charge and this other charge. But what you're really pleading to when you look at the supporting documents, it would have also covered the charges for violation of registration for a foreign agent under the law because he was dealing with foreign governments and not registered and other things. So we're going to go through that transcript and go through it in detail and see exactly what the judge's concerns were in detail. So currently scheduled for 2 p.m. this afternoon. Tune in. We'll go through it. It'll be fun.
Yeah, a lot of people look at that as a big win for justice in that the judge seems as if, you know, she's not willing to just go along to get along. When I look through that transcript, I think you may see, if you look at it, and by the time it gets to the end, this judge has had a lot of opportunities to slam Hunter Biden, far more than she has. When you consider everything with Congress trying to get involved, with the House of Representatives trying to get involved, and some shady activities by his attorneys, which got chalked up as some sort of accident, miscommunication thing, and then you have a situation where the deal here, as you're indicating, and you'll see in more detail when you're going through it, the deal is very layered, where they take stuff as to what, and trying to hide the ball from the public as to all the levels of protection that he has, that he's able to whip out if and when he ever needs it. It's a really fascinating breakdown, and honestly, you're the perfect guy to break it down, Kurt, because you're really good at dissecting these different layers and stuff like that. But from a political perspective, I don't think she's nearly as based as everyone tends to assume, or that she's as anti-Biden. She seemed to have, you'll see as you're going through it, she seemed to have a lot of issues with what her role ultimately would be in this, and just making sure that there's an actual meeting of the minds. But you really need to look at it in detail, and that's why I highly recommend you guys check him out. And if you're not if that's not your cup of tea, I will tell you that I'm going to be doing like a drive. I head up to the mountains now, and I do my thoughts of the week at the end of the week. When I'm doing that drive, I start off on YouTube and then switch over to locals. You really need to follow me on goodlogic.locals.com. In fact, I think I had a speech impediment. It's goodlogic.locals.com. That's goodlogic.locals.com. I learned that from Robert Barnes. And yeah, that's basically it. The only other thoughts that I wanted to give you, because you mentioned I have like a final thought here, and this is something I don't think anyone on this panel has covered yet. I mean, and it's kind of astonishing. This almost, and it's almost, I feel bad, and I need to get this out to you right now so that you can fully understand the depth and importance of analyzing this entire situation here with respect to what's happening with Kennedy. Because oh my God, imagine the impact this would have on our society if, in fact, God forbid, something happened to RFK, and it was the entire structure going back decades, 60 years to the assassination of Kennedy. Literally 60. It's going to be 60 years this November, and going back to all the times that this family has had to deal with the public scrutiny and standing in the public limelight, and they're standing up there as representatives of our government and putting themselves at great personal risk. Obviously, this man's seen his uncle, he's seen his father, he has seen basically everyone in his life step forward into the public limelight and being able to take one for the team. And at the end of the day, now here he is trying to shake up the establishment, and the establishment is basically saying, yeah, we're going to leave you to twist in the wind like somebody rambling at the end of a stream. And that is so completely screwed up. It's so completely messed up to basically the establishment.